I have a special reason to be here as well. I grew up in Delhi. I did part of my schooling in Delhi, and of course, I went to college. I went to St. Stephen's, where I studied economics and mathematics, and then I continued to do my law at Campus Law Center. And traveling by the ubiquitous DTC routes, I would pass by IIT when the conductor would normally proclaim that IIT Delhi has arrived. I always looked with a little bit of what could have been at these hallowed halls of IIT, which I never was able to enter, and looked at them with a certain degree of trepidation and awe. And it's with that sense of trepidation and awe with this Hall of Excellence that I've ventured to accept this invitation and speak to you and share some of my thoughts this evening.
During my days as a law student at the Campus Law Center of Delhi University, one of my friends asked me about my plans after passing out from law school. I replied that I was going to practice law. When my friend heard this, he unsarcastically suggested that I should use my connections to get a gas agency or a petroleum outlet, because that was the only way I was going to make money as a lawyer. Fortunately, I didn't have to go through that to earn a decent income, even if I had a 180 square foot office in the heart of Fountain, Mumbai. But that situation, which was true of India in the 1980s, is no longer true today. When I came back from Harvard Law School and appeared in my first matter, I was given a docket for mentioning before Justice Sujata Manohar. In Mumbai, the fees are marked in GMs, gold mohars. There are no gold mohars which are put into your pocket anymore. In Mumbai, each gold mohar used to be 15 rupees. In Calcutta being superior, was 16 rupees. So I asked my briefing solicitor, how much do I mark for this docket? So he said, it's your first docket from me, so please mark something. I'll pay you whatever you want. And I was very unsure, because I was just learning my baby steps in the legal profession. I said, please tell me, what are the fees? What do I mark for mentioning this matter? So he says, normally a junior marks 3 guineas. Since you have just come back with a PhD degree, I'll allow you an allowance of 5. So instead of getting 45 rupees for mentioning, I was given 75 rupees for mentioning. Justice Saroj Kapadia had become a judge of the Bombay High Court. It was 92. And he used to appear for a very leading public sector corporation. I used to appear as his junior. After his elevation, the time came to test me whether I would be able to continue the mantle of that brief. And we were appearing before a division bench of the Bombay High Court in this very court, presided over by Justice Sujata Manohar. I was opposed by Mr. K.K. Singhvi, the doyen of the Labour Bar and the bar in general. At the end of a very long argument, Justice Manohar, with her characteristic nod of the head, said, "Rule, but no interim relief." The words "no interim relief" were music to the ears of my clients, which meant that I got that brief for the next 10 years before I was appointed as a judge, I think in 2000. And speaking of Justice Bharucha, I appeared here when he was presiding over the court as a judge in charge of notices of motion. My arguments were proceeding in an even tenor when the instructing advocate said something to me, and I blurted it out to the court. And Justice Bharucha looked at me very sternly and said, "You're not his master's voice." What happened to the rest of my argument is now a very blurred memory, because a junior normally shakes when something like that is shown to him or her. But I think we cut our teeth, we learnt our first faltering steps in the shadow of these two great judges. When I was a junior judge at the Bombay High Court, I used to sit in the criminal roster with Justice Ranjana Desai, a very senior and distinguished colleague. During that time, we heard diverse criminal appeals. Initially, I viewed the matters where women were often subjected to the worst of crimes and violations from a very straitjacketed perspective. But sitting with a colleague who had more diverse exposure to realities of gender, gave me the necessary feminist perspective. Of course, I believe that all of us, including myself, have a lot to learn in terms of how we perceive law and apply social experiences. My vision in criminology as a young student was substantially altered when we attended the classes of Professor Latika Sarkar at the University Campus Law Center, when she taught criminology from a feminist perspective. The point which I want to emphasize here is that you must strive to engage with people from different backgrounds and experiences. Such conversations will expose you to diverse thoughts and social realities. In the process, it will make you more humane and kinder towards the others.
While the decriminalization of Section 377 of the Penal Code has enabled queer people to emerge as legally empowered citizens and demand their rights rightfully and proudly, structural changes are still needed to ensure that we are able to extend these positive legal effects to marginalized queer people who continue to face intersecting oppressions. Intersectional discrimination is not something which is only confined to the queer, but certain groups of queer people, due to their caste and class positions, are more susceptible and vulnerable to the abuse of law, both in terms of symbolic and material harm. Over the years, I've had brilliant law clerks from diverse backgrounds, from different genders, a young Dalit student, castes, classes, regions, and cultural experiences, including students belonging to the LGBTQ community. My interactions with them continue to give me new perspectives, whether it is through the suggestion of a new movie or book, or by actively seeking new solutions to old problems. For example, one of my clerks from the batch of 2020-21 gave me an insight into the various issues of governance that people with disabilities face in their daily lives. In our own office, we ensured that the scanned case files we received were OCR readable. Steps were taken to change the visual capture on the Supreme Court of India website to an audio-visual capture, making it more accessible. When I dealt with a case of a young, blind Dalit girl who had been subjected to rape, and when the perpetrator was charged with a crime punishable under Section 376, I learned deeply from the experiential learning which one of my very dynamic young Dalit judicial clerks had brought to the table in our discussions over the year that he spent in engaging with me. I use these examples to show that difference and diversity need to be understood for their uniqueness, which is a resource rather than a liability. From my own judicial clerks who have been members of the LGBTQ community and their friends, I've understood what really happens in society across us. And that enables us to live more fuller, more richer lives as individuals as we transform the lives of others.
Last year, for 5 slots which I had for judicial clerkship in my chambers, I had 650 applicants unconnected with the law. First-time lawyers. Some of my judicial clerks have been first-time educated members of their families. So there is this huge talent in the country which is beckoning for democratizing of the legal profession, for breaking down the feudal structures of the legal profession, for providing access to the unconnected to the legal profession.
I would like to recount the story of Prince Jaibir Singh, a young Dalit student who traveled from Allahabad, now Prayagraj, to Kharagpur, to Mumbai, and ultimately to the Supreme Court in Delhi. Having been allocated a seat in civil engineering at IIT Mumbai, a technical error made Jaibir Singh miss his acceptance fee deadline. He moved the court to allow him to pay the acceptance fee and to facilitate his admission to IIT. Sitting with my colleague Justice A.S. Bopanna, we invoked the Supreme Court's extraordinary power under Article 142 of the Constitution and directed the state to ensure that the bright young student was admitted to IIT Bombay. Special steps in this particular case were necessary since, due to the digital divide and limited resources, technology became an impediment instead of being a great enabler. Jaibir didn't have money to pay the acceptance fee. He had borrowed some money from his sister, but the credit card didn't really give him support at the last minute. Similarly, intentional initiatives aimed at promoting integration in higher education are needed.
As you draw the curtains on your journey of half a decade through law school today, I want you to take a moment to look around you and grasp it all in. You will see your teachers, your friends, and your fellow batchmates. Through you, and this I say on every convocation, never tire of saying that, through you I reach out to my own teachers who have mentored me, to teachers who have taught us the basics of liberal values, of constitutional values, teachers who have taught us our first baby steps in feminist jurisprudence, which was then left to us to develop as life took us through the learning experiences. These relationships which you have fostered in law school are your greatest takeaway from these 5 years of law school. You're bound by the shared experience of a time that will not come back again. Your batchmates will be your friends for the rest of your lives. These relationships that you have built in law school will remain a solid foundation for your upcoming professional life. When I was taking my first baby steps as a lawyer in the Bombay High Court, some of the best briefs that I got were from my own students who I would teach every evening, teaching comparative constitutional law for the LLM students at the University of Mumbai. So our profession is all about relationships, about peer relationships. Convocations are a bittersweet feeling. As you collectively stand at the threshold of what we all on the outside call the real world, you will be filled with anticipation and maybe a little dread about what the future holds for you. And I personally feel that some amount of anticipation is necessary in life. I still anticipate every night before court, and to quote Corin Cooper, when that edge of anticipation is gone, I suppose I'll know that it's time to retire. So in the fond anticipation that I launch on every night before the next day, I do believe that there is still time until the Constitution bids me farewell. Now I know some of you will branch out to be corporate lawyers, some will litigate, some will take up academia, and still there will be some who might branch out of law altogether. Many of us chance upon the law, as we chance upon engineering or medicine, or I dare say even politics. So many of us chance upon the law. You're told that this is the best career for you as a 15 or 16-year-old student, And then you join that area only to realize a few years later that maybe that was not meant for you. Don't be worried about your fears or your desire for change in your life. Whatever the trajectory of your career arc may be, embrace the change that comes your way and never feel the need to be locked into a particular path just because you started out with it. But irrespective of whether you are into litigation, laws, or any other discourse, the real challenge that you will face on a daily basis is the duty to make choices that will not necessarily be one between right and wrong. The most difficult choices which you make, as I know as a judge, are not choices between right and wrong, but choices between right and choices between wrong and wrong. It is possible for right and power to be at odds with one another. Power that commands its legitimacy of being right because it is in accordance with law. Under those circumstances, it is no more a moral choice, but an ethical choice to make. I exhort you to make such choices, keeping in mind whether it promotes the goals of justice in that particular sphere.
So it's these intersectional identities. All of us have different identities. We are an amalgam of a plurality of identities. I don't think any one of us has one singular identity which is definitive of the life which we live or of our experiences.
It is important to acknowledge that while we live in a world that is increasingly becoming divided along social, political, economic, and religious lines, this also leads to the increasing polarization of the truth, where sections of the population contest on your truth versus our truth, even on subjects that are unrelated to the common affinity that the group shares. This is particularly manifest when the political views of an individual interfere with the ability of that person to make an accurate assessment of opinion that is unrelated to their political views. In a very interesting experiment conducted by researchers from the UK and the US, a group of participants was tasked with categorization of shapes. They were asked to categorize shapes. Before the task would start, the participants were given the opportunity to learn the political views and skills on geometric shapes of their fellow participants. When the participants were given a free hand to form groups, it was found that participants grouped themselves with those whom they share close political affinity, though the task at hand was only to categorize shapes. This tendency to exhibit epistemic spillovers has led to the manifestation of multiple truths in society. No consensus is reached on the identification of the truth due to our tendency not to be able to accept or even consider the views of those whom we reflect to be different from us. We subconsciously filter the truth that does not align with our interest. We only read the newspapers that align with our beliefs, ignore books written by people who do not belong to our stream, and turn the TV on mute when someone furnishes an opinion contrary to ours. In sum, we do not truly care about the truth as much as we do about being right.